Good afternoon and welcome to Division 5 of the Colorado Court of Appeals. We have two cases on the 1:30 docket for this afternoon. Looks like counsel for the first case are obviously here. Our counsel for the second case checked in. Okay, good. A couple of preliminary things before we get started with the arguments. Obviously, I'm Judge Jones, and on my right is Judge Terry, and on my left, Judge Grove. I'm sure you're familiar with our procedures. I'll go over a couple of things just by way of reminder. To those of you in the audience who have cell phones, you should probably turn those off, as those can interfere with our recording equipment and also could interrupt the arguments. We don't want that to happen. The arguments are recorded and they are live streamed. Also, counsel, when you come to the podium, just remember that there is a toggle switch that allows you to raise and lower it as needed. Are there any questions about how we'll proceed? Okay. Counsel?
Good afternoon. My name is Megan Morris, bar number 43963. I represent Mr. Thomas in this appeal, and I also represented him in his previous appeal to this court. There are 4 independent reasons to reverse and remand for a new trial here. I laid those out in my brief, but I would like to try to touch on them each briefly today. Obviously, if the court has questions about a particular one, I'm happy to focus there. Those 4 reasons are, first, that the trial court had no independent recollection of the proceedings here and therefore couldn't make the factual findings it needed to make on remand. Second, that it exceeded the scope of this court's remand order and violated the mandate rule. Third, that the prosecutor would not have struck Juror J based on his body language alone, and under Snyder, reversal is required in that circumstance. And fourth, the merits of the Batson analysis here, the prosecutor's explanation that she did struck Juror J based on his body language was implausible based upon the record. Starting with the first reason, the trial court lacked recollection of the proceedings here, which is not surprising given that it had been several years since the trial. Because of that, it was unable to make factual findings that were necessary. In particular, it was unable to recollect the juror's demeanor here or the district attorney's demeanor from the time that she made the Batson challenge, or from the time that she was responding to the Batson challenge. And without that recollection, that given that this was a body language reason under Craig v. Carlson, reversal is required here.
Counsel, in Craig v. Carlson, that involved a successor court, one that was not, that didn't preside over the first proceedings.
That's correct.
But my recollection from that case is that the court did hold a hearing on remand. And so how do you reconcile that? I mean, the successor court obviously can't have any recollection of what happened before.
Right. So what Craig v. Carlson says is a successor court can hold a hearing, or here I think this court is in the same position as a successor court, being one that doesn't have the recollection of the Batson proceedings at issue, but it can only uphold the prosecutor's challenge if there's concrete record support for the reasons that the prosecutor is giving. So there was support within the juror questionnaires that supported the reason for the prosecutor's challenge. Whereas here, this court remanded solely on findings for the juror's body language, which were not reflected anywhere within the record that we have. And so I think that's what makes this reversible error under Craig v. Carlson.
Counsel, but why can't the prosecutor's recollection substitute for the, as you put it, concrete evidence in Carlson? It's just a different kind of evidence.
It is a different kind of evidence, and I think there are a couple of responses to that. I think ultimately, when it comes to Batson, the trial court is the one who has to make these factual findings. And evaluating the prosecutor's demeanor at this time of the remand hearing several years later is an insufficient substitute for evaluating her demeanor at the time that she's responding to the challenge. This court and the Supreme Court have often recognized that the best evidence of the prosecutor's intent in making that challenge is going to be her demeanor at the time she's exercising the challenge and explaining the challenge. And because the court could not remember that demeanor here and couldn't evaluate properly whether the juror's demeanor could plausibly be said to reflect the body language that the prosecutor attributed to him, it was unable to make those necessary factual findings here. And so I don't think it's enough that he was able to evaluate the prosecutor's credibility at the remand hearing itself. I would note in Mr. Thomas's first appeal that the state in fact conceded that if the trial court did not remember the proceedings here, that reversal would be required. And so I would argue that consistent with Craig v. Carlson and that concession, that reversal is required here. Moving to the second argument, that the trial court exceeded the scope of the remand here and violated the mandate rule. This court remanded specifically for the trial court to make further findings regarding the prosecutor's assertion that Juror J's body language suggested that he did not understand the concept of circumstantial evidence. Yet here on remand, the prosecutor expanded her rationale for striking this juror. She talked about his tone and his pauses, and the district court found that it and this court had previously misunderstood the district attorney's reason for striking that juror, saying that the rationale as presented by the prosecutor during hearing on remand is more subtle than the analysis engaged in by the court during trial and the appellate court. And so I think what's really problematic about this is it seems that the trial court is allowing the prosecutor to go back to step 2 of the Batson analysis and provide a revised or a different reason for striking the juror, rather than simply analyzing at step 3 whether the reason that she gave at the time of trial was plausible in light of the record.
But how can we conclude that the prosecutor gave more reasons on remand than she did during the trial, given that we know that part of the colloquy was not transcribed during the original trial?
So what we have at the original trial is it seems that the trial court chose to make a sort of off-the-record bench conference, but then allowed the parties to make their full record afterwards. So after the full jury was impaneled and then excused, it allowed the parties to make a record on their Batson, on the Batson proceedings.
Well, how can we assume that the reasons that were given in the remand hearing were not the same ones that were given in that informal, untranscribed portion?
Well, I think because the trial court specifically provided this mechanism for the parties to make a record, I think that's what we have to rely on for the prosecutor's reasons for striking this juror. And so I don't think we should assume that there's anything beyond that in that untranscribed portion. This seemed to be the trial court's specific method. It's also how they made records on challenges for cause after all the jury was impaneled. And so it seems to me that because the trial court provided that specific way of making a record for the parties, that that's what we should be looking at. I would also note that the district attorney...
What's the point of having a hearing then? Why not just rely on what's in the original record? I mean, in the remand instructions, the court said that the parties can talk about their recollections, and the court could rely on that.
Yes, and I think, so specifically though, I think that what this court was talking about, and the way I read this court's remand order is again as a step 3 remand. So a remand regarding that specific assertion that Juror J's body language suggested that he didn't understand the concept of circumstantial evidence. And so this court was asking the court to make further findings about whether or not that was plausible in light of the record. And so I think the court could have taken the prosecutor's assertions about what she believed the juror's body language showed, which it did. It could give its own recollection of that if it had any, which it did not. It took evidence in terms of the prosecutor's jury selection notes. So I don't contest that any of that was improper. What I do argue is that it went beyond the court's remand order in the sense that it allowed the prosecutor to revise her original explanation for striking the juror. So when she originally said that she struck him due to his body language and more importantly his answers showing confusion about the concept of circumstantial evidence, on remand instead she was talking mostly about his tone and his pauses, and that those somehow showed that he didn't understand or wasn't agreeing with her line of questioning about circumstantial evidence. And so it's allowing her to revise that rationale for striking the juror that goes beyond this court's remand order and violates the mandate rule. Moving to the third reason for striking the juror, under Snyder v. Louisiana and Collins from this court, where the prosecutor gives a sort of two-part reason for striking a juror that's based on both the juror's body language and the juror's statements. And then the statement-based reason is shown to be implausible based on the record, which happened in Snyder and also happened here. Then at that point, unless the record reflects that the juror would have been struck based on their body language alone, reversal is required under Batson, or the Batson challenge should be upheld. And so that's what we have here, where the juror's answers, he was giving specific explanations of the concept of circumstantial evidence. So the fact that he was struck based on his answers was implausible. And indeed, the court originally rejected that explanation.
Counsel, I'm not so sure they're implausible. What we have are contradictory answers. We have case law dealing with contradictory answers. The court can decide the prosecutor can decide which ones the prosecutor thinks are more sincere, and the court can do the same. So in other words, it's not dispositive that at the very end, the prospective juror says, oh, I can put that aside, or I understand that.
Sure, and I agree with that. But here, the trial court, ruled that the juror ultimately agreed with the prosecutor and seemed to reject that reason for striking the juror, and that's what this court held in its previous opinion, was that the trial court had already rejected that statement-based reason. And so at this point, I think we're at the position where now we have to evaluate whether the juror would have been struck based on body language alone. And given the way that the prosecutor talked about body language, it doesn't seem likely that that was the case, because to her, the answers were the more important reason. And because on remand, she was focusing, again, more on tone and pauses rather than body language. I think the only thing she said about actual body language at the remand hearing was that the juror was leaning back, and it's sort of hard for me to understand how leaning back could communicate a confusion.
Do you think tone and pauses is that mutually exclusive of body language?
I'm not sure. I think I think it could be beyond body language, because when I hear the term body language, I think of facial expressions. The leaning back does seem like body language. I think she also said at one point the juror was staring at her, so that sounds like body language to me, versus tone and pauses seems more like demeanor, and is potentially not encompassed within the body language explanation that she gave originally. Sorry, go ahead.
No, go ahead.
But I think that sort of shifts to my fourth point, which is that the fact that the prosecutor kind of shifted her explanation and didn't describe any of these purported demeanor-based reasons for striking the juror, but instead just said, that his body language and more importantly his answers were her reason for striking him. The fact that she shifted her explanation is one of several reasons that the record undermines the plausibility of her reason for striking Juror J. And implausible justifications should be found to be pretexts for purposeful discrimination. That's sort of our main focal point in deciding whether or not there has been discrimination in a Batson challenge. The juror here, he said the word speculation, but he ultimately agreed with the prosecution about the concept of circumstantial evidence and was actively explaining it rather than just giving yes or no answers during part of that colloquy. I would also note that here, something that's problematic about what happened at the remand is that the trial court credited what the prosecutor said about the juror's demeanor. So even if we are considering that demeanor more broadly rather than just body language, we have the public defender did in fact contradict what the prosecutor said, and yet the trial court failed to make a resolution of those contradictory testimony. Instead, it just credited the district attorney without explaining why it shouldn't credit the public defender, who said that he just had a normal demeanor, that there was no recollection of him seeming confused or shaking his head, that he was polite, that he didn't have much of a facial expression, and that he seemed to just be answering the questions. And there I'm referring to pages 19 through 20, 24 through 25, and page 39 of the remand transcript. So here, the public defender is, I think, actively contesting what the district attorney is saying about the demeanor, and yet the trial court fails to resolve that conflict. And under the Dorsey case from Florida, that essentially results in the trial court failing to make a factual finding that it needed to make here. So unless the court has further questions, I would ask the court for those 4 reasons to hold that the trial court should have granted the Batson challenge and reverse and remand for a new trial here. And I would reserve the rest of my time.
Thank you, counsel.
May it please the court, my name is Erin Grundy, registration number 41271, and I represent the people of the state of Colorado. This court's remand order should be affirmed because the court appropriately followed this court's remand directives and was able to make thorough and adequate Batson findings regarding Step 2 and Step 3 based on precisely the type of evidence that this court directed it to do so. This court's remand directed that the court make further findings on the Batson analysis and specifically to make findings regarding the prosecutor's assertion that Juror J's body language suggested that he did not understand the concept of circumstantial evidence, notwithstanding his verbal responses to the prosecutor's voir dire questions. This court's remand further directed the court to consider all pertinent information, relevant voir dire notes taken by counsel, if offered into evidence, the record of the verbal responses, the recollections of the court and counsel, and the court's assessment of credibility of counsel regarding the factual assertions. It had all of that evidence before the court, and an independent recollection by the court is not required. Indeed, we don't require, even for demeanor-based strikes, for the court to personally observe the strikes during the trial. So to do so on remand seems illogical and an expansion of the rules, and certainly not within the scope of this court's prior order. Here, the prosecutor had her notes from the first trial. She introduced them and indicated the check marks, the plus marks, and that the particular juror who was struck, Juror J, had 2 negative marks. She also indicated that she struck every juror who had 2 negative marks, which the court certainly has that information, including those actual notes in the court file. In assessing the verbal responses, the court is also looking at the nonverbal responses. And my position is that body language includes all components of nonverbal responses. It's your tone, it's your demeanor, it's how you answer the question. It's the reason why yes and yes don't mean the same thing, even though they appear the same in a cold transcript. And it's why trial courts and prosecutors and defense counsel are the ones who actually are able to assess the veneer, are able to make these strikes, and are able to make a record at the time of trial. And then, when that record is inadequate, are the ones that we task to make the record for the appellate court. Because if not, we'd be looking at nothing but the transcript. There would be no reason to remand a case if we weren't looking for additional evidence to be brought before the court so that further factual findings could be developed. That's exactly what the court did here. It assessed the cold record that we have before us. It assessed the notes, it assessed counsel's recollection, and I disagree that it didn't analyze defense counsel's recollection of the case. When the court indicated just before it released the parties at the conclusion of the remand hearing that it was going to consider the prosecutor's credibility, it indicated that it would also consider the public defender's credibility, not only as an officer of the court, but also as a witness who'd offered testimony in the case.
Ms. Grundy, can I ask a question about Craig v. Carlson?
Of course.
So it says, and I'm quoting here, "We note that when a successor court cannot confirm a proponent's credibility in offering a non-discriminatory reason through the record or through jury questionnaires, a new trial is warranted." What does "through the record" mean in that excerpt?
I think through the record means a number of things, and we're talking specifically about a successor court, so I think the trial court is somewhat limited. When it is a successor court, it didn't have the ability of sitting through trial, it didn't have any of that. So for the context of a successor court, the jury questionnaires, voir dire notes would certainly be something that the court could consider as part of the new record on a remand hearing. It could consider the transcript. In Craig v. Carlson, it considered specifically the questionnaires and the transcript, but I don't think that Craig stands for the proposition that a trial court is limited to only those components of the record. Certainly any component of a record that the court can fairly hear, which would include voir dire notes, would also include the recollections of counsel. Now, there may be some demeanor-based things where it would be harder for a successor court to make a ruling, But I'd also note that in Craig, the court actually made a ruling and upheld the Batson finding that there was no purposeful discrimination shown.
Given that this particular judge didn't have any independent recollection of this juror and this interaction, should this judge be treated as a successor court, or should it be? Is there any reason to treat it differently than Craig v. Carlson suggests?
Yes, because this court was not a successor court. So I think it's a unique rule that stands for the proposition when a court is stepping in for the first time. And one thing that some of the other cases that we've cited in the briefs note is when it's a new judge, when the judge has left the bench, when it's been 7 years past, some of those situations may make a remand far more difficult when you have a new judge, all of those situations. But when it is the same judge who's presiding over the Batson hearing that they heard before, it may trigger some recollections. Now, this court said it didn't have a specific recollection here, but it certainly did have experience with the parties. It could assess the transcript, which may have also sparked some independent recollections. So I don't think that a successor court and the same court should be treated the same. But even if it was, there was an ample record before this court to make adequate findings for Batson Step 2 and Step 3. And I disagree that the prosecutor demonstrated different reasons here. I think what the prosecutor did was exactly what this court directed her to do, which was to explain her reasons. And at trial, for the portion that is recorded, she said, "I don't want to say quick, but I made follow-up attempts trying to rehabilitate Mr. J, and I did not believe, based on body language and, more importantly, answers to my questions, that he was even more convinced that, in fact, he understood the idea of circumstantial evidence even after that example." And at the remand hearing, she explained that answers don't just mean verbal responses. They mean the body language, they mean the demeanor, they mean the tone. I think all of these are things that the court could properly consider. And during the remand hearing, the prosecutor specifically demonstrated with her own voice the type of pause and the type of tone that she was referring to. But of course, we don't know what those pauses and tones are in the cold record because we can't hear them. But the trial court could. The trial court could assess that, could assess counsel's recollection, and credited the prosecutor's strong recollection combined with her voir dire notes, as well as the transcript of the hearing, when it rendered its findings. I think this was absolutely consistent with this court's remand order and exactly the reason why remands exist. We ask trial courts to make remand findings on far more difficult questions. We ask them to make findings on Arguello, on Curtis, on Brown, sometimes years after. We also ask them in post-conviction to assess credibility years and sometimes even decades after the conviction occurred. We do this of successor courts, often in post-conviction contexts. Trial courts can and do assess credibility, and they do so without an independent recollection. No such independent recollection should be required here, nor have the cases from our Supreme Court or the United States Supreme Court required it in the past. Additionally, I disagree that the people initially conceded at the first trial. The question at oral argument at that point was asked by the court, if the trial court says, "I have no memory of this and no basis on which to resolve the prosecution's assertion that the man was struck." So there it was, "I have no memory and no basis." We still agree with that position. Had the trial court said, "I have no basis on which to resolve this," the court's only option would have been a remand. But here the court did have a basis. So there was no reason why the court should have been required to reverse the findings. If this court has no further questions, the people ask that this court affirm the ruling of the trial court because it had adequate information in front of it to make findings at Batson Step 2 and Step 3, and it did so within the scope of this court's remand. Thank you.
Rebuttal?
Under Craig v. Carlson, a court doesn't, under this court's precedent, a court doesn't need to observe a juror's demeanor to rule on a Batson challenge that's related to the juror's demeanor. But it must be able to decide whether or not that juror could have plausibly be said to exhibited that demeanor, and that means having some recollection of the jury selection and the proceedings relating to that juror. Here, the court did not notice any distinct demeanor from this juror, and that seems where the prosecutor is attributing fairly distinct demeanor to this juror while this juror is being questioned. It seems unlikely that the court would have not noticed that either at the time of trial or had memory of it later. And under Craig v. Carlson, this court, the trial court should be treated as a successor court because it's in the same position. It has no memory. It's the exact same as a successor court. I'm not sure what the distinction would be. A successor court might also have experience with the parties, but it has no memory and no first-hand knowledge of what happened at jury selection. So that's what we have here. So because...
Counsel, let me ask you about that. I mean, at step 3, the defense has the burden, correct?
That's correct.
So the defense, it seems to me, had the burden of establishing that the prosecutor's stated reason was untrue. If there's no independent recollection by the court and the court doesn't credit the testimony of the public defender, how can the court find that?
I see my time is up.
Go
if
ahead.
I can respond. So I think at this point, Craig v. Carlson acts as a sort of exception to that rule, where if there is a lack of concrete evidence in the record, the court's just simply unable to make those step 3 findings, and because that's not fair to either party, the appropriate remedy is a new trial. So for those reasons, I would ask this court to reverse and remand.
Thank you. Counsel, ready to proceed.
May it please the court. My name is Katarina Donnelly, and I represent the appellant, Mr. Luper Delgado. We have received the questions that the court submitted, I believe, on Monday evening, and if I'm assuming that's what the court would like us to address first, so I'm going to go and address the first question first. I believe the question was whether this case is distinguishable from People versus Carmichael. The principles in Carmichael, the principal question is the same. We have a defendant in Carmichael who alleged ineffective assistance of counsel based on what happened during the plea negotiation stage. Same here. Mr. Delgado's first issue on this direct appeal of his 35C denial was the fact that he did not receive an effective assistance of counsel. In fact, the plea offer was not even conveyed to him. So in that sense, we are fundamentally dealing with the same question. Carmichael, as the court is aware, was decided in 2009. We heavily relied on Lafler, that was decided by the Supreme Court of the United States in 2012. And the second question was whether Lafler has overruled a portion of Carmichael. What happened in Carmichael was, after recognizing that, of course, there is a fundamental right, constitutional right to effective assistance of counsel at plea negotiation phase, considering the fact that, at least based on the information that the Supreme Court relied in Lafler and its sister were accompanying case decided on the same date in Frye, 95% of the cases, criminal cases nationwide, are resolved through plea bargaining. So the court, all of them had agreed so far that based on the significance of what happens during that phase, it is a critical stage. There is a right, a constitutional right that extends to that stage, and probably one of the most significant ones, considering the fact that most of these cases are resolved via plea agreements. So what happened in this case, in Carmichael, the Colorado Supreme Court considered some of the other states and circuit courts that had decided as a remedy for that violation of the constitutional right, that what would they do was to offer a new trial, but also accompany it with reinstating the initial plea offer. The Colorado Supreme Court looked at that and said, no, we do not think that there is a constitutional right that would justify that remedy. The remedy in the state of Colorado is going to be a new trial. 3 years later, both in Lafler and Fryer, the Supreme Court of the United States decided that as a matter of constitutional law, based on the Sixth Amendment and the interpretation of Strickland, there is a constitutional right to address that harm. The harm was not just lack of assistance of counsel during the plea bargaining negotiation phase, but also losing the offer that was on the table. So the Supreme Court specifically addressed that harm and decided that the remedy would be to reoffer that same plea offer to the defendant, and then left it to the states that in addition to that remedy, so use that as the base and then go up from there to add remedies that the state seems adequate after that base constitutional remedy. So if the question of the court is that whether Carmichael was overruled by Lafler as a whole, I don't believe that it was overruled as a whole. It was overruled to the extent that Carmichael did not seem it appropriate to reoffer the plea. That part of it is overruled, but of course, the Colorado Supreme Court, based on what Fry and Lafler had specifically said, are free to provide for additional protections in these circumstances. The examples given were, for example, under the state laws, as the court is aware, sometimes the prosecution might have the discretion and authority to withdraw the offer, or the district courts, as is the case in Colorado, would have the discretion under very limited circumstances to reject the offer. Lafler and Fry specifically go as far to say that it might be appropriate under these circumstances for the state to say, not only we are reoffering the plea offer that was on the table, but also the prosecution is going to be prevented from withdrawing the offer, and the district court is going to be prevented from rejecting the offer in those cases.
Ms. Donnelly,
Yes,
is
Your Honor.
there anything in the record, aside from the allegations in the 35C motion, that demonstrates what the plea offer was?
No, Your Honor, because there was no hearing, and that was the fundamental problem with this issue, that the court did not consider Carmichael, did not consider Lafler, did not consider Fry. There was no consideration of the fundamental question.
So the prosecution never put this plea agreement offer in writing or anything like that?
Not that I'm aware of. There was nothing in writing in the record. The fact that it was or it wasn't was not in the record. And as you're aware, this is a direct appeal, so I don't have any access to what is in the file.
So here's my concern. In Lafler, it suggests that the court would also have to accept the plea. That's one of the components in that case. Here, the offer, supposedly, if it was made, was for a determinate sentence. Yet, Mr. Delgado was convicted of something that required indeterminate sentencing. So what assurances do we have that, or what assurances appear in the 35C motion that the offer was made in a way that the court could accept it?
Your Honor, the test is the reasonable probability test. That is the test that Lafler put in because of the fact that we don't know the answer. because of the fact that there was no hearing. And that is the problem in this case. There was no hearing. These issues were not discussed, so we don't have the initial facts to answer that question. Therefore, the test is whether a reasonable probability that based on what Mr. Delgado has put in his 35C petition, if we take those as true, that it would be reasonably probable that he would have accepted it. We know objectively for somebody who has been convicted or was going to face conviction for sexual assault on a child in possession of trust, that an indeterminate sentence plus being put on the sex registry was a given. So for somebody like that, when you give him a 10-year sentence, any objectively reasonable person, let alone a lawyer, would have advised the client that you would be facing something far more intense if you go to trial and you get convicted. This is what Mr. Delgado was not the opportunity to discuss, to consider, was not even aware of the fact that he was given that offer. So if we
Counsel,
take,
I think
I
though,
apologize.
to get to what the problem is that just an offer of 10 years by itself wouldn't be a legal plea under the circumstances. And the court can't accept an illegal plea. In other words, the court couldn't hold him convicted of the same charges and impose a 10-year determinate sentence. That would be illegal.
Your Honor, the problem that we're having, one is that the issue has not been raised by the prosecution, which lead me to believe that, in their opinion, there wouldn't have been a problem with the accepting of that. But if that is the issue, the problem that we're having right now is that there is no testimony in the record as to what the actual offer was.
But doesn't he have to plead what the actual offer was?
He has pled what his knowledge is based on what he was told. And that is the basis of having the post-conviction rights, to have a hearing so we can have the counsel testify as to what the actual offer was, for the prosecution to admit it or reject it. And then based on that, the trial court makes a decision, a reasonable decision as to whether this was an illegal offer, which under those circumstances, when the case law would support that, the prosecution could have withdrawn the offer, set aside the fact that the court could have rejected it. But we don't have that information because we are dealing with a pro se litigant who has conveyed his knowledge of what the offer would have been. That is why we have those hearings, that when the issue has been raised and there is a reasonable probability that there was an offer that could have been something that he would have taken, why not have the hearing so we are not standing here and speculating as to what the offer is?
Well, in Lafler, the court seemed to impose a couple of other requirements for showing prejudice. It used to be, like under Carmichael, that the defendant could establish prejudice simply by alleging, I would have accepted the offer, okay? But the court in Lafler says you have to allege that, okay? And that the prosecutor wouldn't have withdrawn the offer, and that the court would have accepted it. And neither of those latter two appear in the motion, which was filed after Lafler. So in other words, isn't his 35C deficient on its face for failure to make the allegations of prejudice that Lafler requires?
Well, Your Honor, are you referring to the pro se petition?
I'm referring to both of them. I
Right.
have the typewritten one by supplement by counsel.
Right.
Yeah, and it doesn't allege either of those either.
But what is fascinating is that in this case, now it was briefed in 2018. We have no mention of Lafler, we have no mention of Carmichael in the prosecution's briefings. So having hold Mr. Delgado, a pro se litigant, to the standard we are not even holding the prosecution to know the governing law, it would be at least unfair under the circumstances of this case. But also the fact that if his counsel is ineffective on post-conviction, that's another problem that we're having, right? That this is not something that has been conveyed to the system. There are not very many cases. This is the first time. This is an issue of first impression, as the court is aware. So if this is an issue of first impression, then how could a litigant, a pro se litigant in the state system, be held to that burden of knowledge and pleading if this is a question that has not been addressed by this court or the Supreme Court of Colorado, Your Honor.
So you would concede then that the defendant is bound by and bound to know of a decision by this court or the Colorado Supreme Court, but not the United States Supreme Court? That's what you're saying.
Of course, the United States Supreme Court would govern all of us, Your Honor.
Okay,
My
not a question
point-
of governing, but what you have to plead. If the court, the Supreme Court of the United States says you got to have these three things to show prejudice, he
Well-
gets excused from that because he's pro se?
Your Honor, I think the pleading standards of pro se litigants applies, that we always interpret that broadly. So as long as they're saying that I have been prejudiced because of this, that should be enough, especially when you're dealing with post-conviction on something this technical. So my position would be on behalf of my pro se client at that time that he cannot be held to the standard. We are not holding the prosecution to include the governing case law in their briefs.
Well, he's not really pro se. I mean, he had counsel who filed the supplemental 35C, right?
Yes, Your Honor, but then that would be the issue of ineffective assistance of counsel and that stage, something that probably we wouldn't want to go there at this point, and just getting to the part that a hearing would have fixed all of these issues. If the court doesn't have any further questions at this point, I would like to reserve the remainder of my time.
May it please the court, Carmen Moraleda on behalf of the people. My attorney registration number is 34852. So I'm going to dedicate my time to answering your questions, which I think also address the questions you posed to opposing counsel. But if I may, I would like to answer the Lafler v. Cooper related question first, and then I'll move on to the Carmichael question second. And I will directly answer the question whether Lafler v. Cooper implicitly overruled Carmichael's holding regarding remedy. And I think the answer is yes, overrule or modify Carmichael's holding to the extent that Carmichael requires a new trial as the only or more appropriate remedy in all circumstances. If I may elaborate a little bit about Lafler, because Lafler, as this court has acknowledged, sets forth the test that applies in this case. Lafler set forth the test for determining ineffective assistance when counsel's deficient advice led defendant to reject a favorable plea offer. In this circumstance, to show prejudice, defendant must show that but for the deficient advice, there is a reasonable probability that three things would have happened. First is that the defendant would have accepted the plea. Second, that the prosecution would not have withdrawn the plea. And third, that the trial court would have accepted the terms of the plea. Now, if the defendant satisfies this burden, the Supreme Court held that the remedy might either be resentencing to a lesser sentence, and in some cases might be to require the prosecution to reoffer the plea. But it emphasized that the trial court retains discretion regarding the convictions, whether to vacate them, whether to maintain, and also what the appropriate sentencing should be. And also noted that the remedy should not require the prosecution to incur the expense of conducting a new trial. So that's what Lafler, as I said, has overruled, modified Carmichael to the extent that Carmichael requires a new trial as the only remedy or the most appropriate remedy. But in any event, I would like to point out that in this case, the remedy would be to remand for an evidentiary hearing, not a new trial, and not ordering the prosecution to reoffer a plea, because both Lafler and Carmichael, the remedy came after evidentiary hearings were held. Now, moving on as to the second question, whether the circumstances here are distinguishable from Carmichael, the answer is yes. To begin with, in Carmichael, an evidentiary hearing was necessary, and here the existing record established that defendant's allegations, even if true, did not satisfy Strickland's prejudice prong. Carmichael held that defendant has the burden of providing objective corroborating evidence to support his claim that, but for counsel's misadvice, he would have accepted the offer. But and there were several sources of evidence there. In Carmichael, that supported defendant's claim. One of them, the most important, was the fact that defendant was actively and affirmatively pursuing a plea deal. Here, as I said, the record, as it is, establishes that the allegation, even if true, do not satisfy Strickland. First of all, and this is, I guess, the important thing that for this course to notice, the record refutes a reasonable probability that defendant would have accepted the plea offer because, in fact, defendant essentially rejected a similar offer to 11 years and a stipulated 11-year sentence that was extended before the second trial. And defendant did not allege that he was misadvised by his other counsel who was appointed for the second trial regarding that offer.
Can we look backwards like that? I
Yep.
mean, that's in hindsight, and you're saying that he rejected it before the second trial, but he's looking down the barrel of a conviction, and there's no certainty as to how his appeal is going to come out. And so how can we take what he did before the second trial and compare it in any sort of, how does that square?
Well, because, so the court here, you have to look at the entire record, the whole record. And if defendant rejected essentially the same offer, and he did not allege that counsel misadvised as to the sentencing exposure, that's evidence in the record that supports that there's no reasonable probability that he would have accepted the same offer.
But he stood in a very different position when he got the second offer. The convictions had been reversed. When he got the first offer, he was convicted, okay? So he's not exactly in the same position. He may feel like, I've got a decent shot at an acquittal here, where he could have had no such thought when he got the first offer.
Okay, well, in that case, my response is that in this court, so as you're acknowledging, after the first trial, defendant appealed, the convictions were reversed, and a division of this court remanded for a new trial. And that gave defendant the opportunity to re-engage in plea negotiations, where the record supports that they did, which, according to Carmichael's holding, that remedies the prejudice caused by constitutionally deficient advice concerning sentencing exposure in the plea bargain. And that's part of the trial court order in this case. The court said any deficient advice regarding the plea offer was remedied because the convictions were reversed and the case was remanded, and there were new plea negotiations which the defendant rejected.
But isn't that what Lafler overrules? I mean, the reason Carmichael talks about remedies and says that the remedy of requiring the plea offer to be given again so that the defendant can take it as off the table, okay, not a remedy, okay? So in that circumstance, if you got a new trial under Carmichael, yeah, okay, no prejudice. But in Lafler, the Supreme Court put it back on the table. So that is an appropriate remedy, and I think the subsequent case law would indicate that is usually going to be the remedy. So it seems to me that we have to look at the change in the landscape on remedies in terms of determining whether there was prejudice. We can't just say the prejudice was cured because he got a new trial, because, well, that's not the only remedy available anymore.
No. He got a new trial, and he had the opportunity to re-engage in plea negotiations.
But Lafler addressed the argument by the government that getting a new trial would be sufficient, and they expressly rejected it.
Yes, but Lafler did not preclude remedies or a new trial as the only remedy. Lafler said the remedy in some cases might be resentencing, other cases might be require the prosecution to reoffer. But Lafler doesn't require that the prosecution reoffer the agreement, and explicitly said that the trial court retains discretion to ultimately determine what to do regarding convictions and the sentencing. So I don't see that Lafler kind of precluded any remedy over another. It simply said in some cases this might be the remedy, some other cases this might be the remedy. But
So if it's up to the trial court, shouldn't we just send it back to the trial court and let it decide what to do?
well, I think the trial court in this case, with the record as it is, had enough to deny the motion, concluding the defendant had failed to establish prejudice. As this court were noticing, I mean, Lafler requires the reasonable probability, again, the defendant would have accepted the plea, that the prosecution would not have withdrawn the plea, and that the trial court would have accepted his term. Here, defendant did not even plead that the prosecution would have not withdrawn the offer, and that the court would have accepted the term. And in fact, and this answers, or I guess has to do with your question, Judge Grove, the record doesn't support a reasonable probability that the court would have accepted a 10-year determinate sentence, because defendant's crimes as charged and as convicted were subject to mandatory indeterminate sentencing under SOLSA, the Sex Offender Lifetime Supervision Act. So defendant has failed to both plead and also establish a reasonable probability that the court would accept the plea offer as alleged by defendant.
The cases decided after Lafler in the courts talk about those two additional requirements in terms of additional information that might come to the attention of, say, the prosecutor or the court that would give it a reason, give the prosecutor a reason to withdraw, or give the court a reason not to accept. In other words, it's not something the court can just refuse to accept willy-nilly, it seems. It's got to be a reason. And without knowing exactly what the terms of the plea offer were here, how can we do anything but speculate as to whether the trial court would have accepted it or not?
Yeah, but Your Honor, the defendant has the burden of providing enough allegations that, if true, would entitle the defendant to relief. So it's burden, and he has failed to meet that burden. So, because otherwise, every time defendant fails to say something, are we going to remain for a hearing? That's going to be most of the cases. So he has to allege sufficient fact that, if true, would entitle him to relief that would satisfy both prongs of Strickland.
I want to make sure I understand your position. I think I heard you say that the court would not be permitted to accept a determinate sentence as part of a plea agreement. Is that what your position is?
What I'm saying,
if so, why?
sorry. So as it was pled, the defendant was offered a 10-year determinate sentence. I think there is no reasonable probability, without knowing more, that the court would have accepted the offer, because the defendant was convicted of sexual assault on a child and incest, and both of those crimes require indeterminate sentencing under SOLSA.
But, so you're saying the court could not, there's no circumstances under which the court could accept that plea?
Well, if the plea is pleading guilty to those crimes, I don't think so. Now, if the prosecution had offered a plea to other crimes not subject to SOLSA, maybe the court can definitely use its discretion to accept the plea. But if the crimes are subject to SOLSA, I don't think the court has discretion to impose a determinate sentence.
Do you have any authority for that?
I do not, just the SOLSA requirement, I mean the SOLSA itself, and also cases from this court that SOLSA requires indeterminate sentencing. Actually,
Counsel, I think that in 2003, when this was allowed or alleged to have occurred, the aggravated incest conviction did require indeterminate, but I don't think the other ones did. I think that was changed later. So there could have been a plea to one of the offenses or two of the offenses of conviction to run concurrently for 10 years.
so I think that both a sexual assault on a child, both of those, one is under 15 and over 15, they're both subject to mandatory sentencing.
They are now.
Yes.
I'm talking about 2003. And when I went back in the statute books, it looked like just the aggravated incest was.
Okay, that I'm not familiar.
I can't say that for sure, but it looks like it.
And I don't know for sure, so
Yeah.
I'm not gonna.
Can I ask you a question, though, about the first prong of the Strickland test?
Yes.
Because the court seems to have denied the motion based on both prongs. The court found it fanciful, I don't know if that's what the term the court used, that any such offer would have been made. That seems kind of speculative. I mean, if the prosecution believed it had problems with the appeal or something like that, it's not unheard of to have post-conviction plea offers.
Yes, and in fact, I think the court, they have to accept the allegations as they were true. So if the defendant alleged that there was an offer, that the court has to accept, okay, that was true, and counsel provide incorrect advice, told me not to accept it because the maximum I could get 15. that should have been accepted as true. But the court, I think, in looking at the rest of the record, determined that I think the prejudice prong wasn't met. So, and sometimes the way they express things might be a little bit tricky.
The court, though, seemed to say, I don't believe that this offer was made. Do you agree that that's an appropriate finding for the court to make?
Not at that stage, because it's a summary denial. I mean, a different thing would be if there was an evidentiary hearing, then the court can make credibility determinations. But in looking at everything else, I think the court's ruling was proper, and of course this court can look at everything in the record to support the court's ruling. So unless there are any other questions, my conclusion is that the court here properly denied the motion without a hearing because the existing record refuted the allegations and defeated the claim of prejudice. So unless there are any other questions, we ask that this court affirm the trial court's order to be affirmed. Thank you.
Thank you, counsel. Rebuttal?
Your Honor, Mr. Delgado agrees that Lafler and Fry answer your questions. The government in both cases made the same argument that the new trial would be the remedy, and the Supreme Court of the United States in both rejected that argument. As to the issue of what was the content of the offer, I think all these questions illustrate the problem that we are having now here. Going back to the standards, what we asked for was a hearing. Mr. Delgado is entitled to a hearing because, looking at this record, based on the case law that actually governs that issue, which is Ardolino, unless the court can look at the record before it and answer all of these questions, it cannot not give a hearing to Mr. Delgado. That's why we are having all these questions that we cannot answer. But what we know is that regardless of what the terms of the offer were, the fact that the offer was not conveyed to him, that alone is the constitutional violation that both Lafler and Fry had mandated a guarantee for. That when that happens, that when the offer is conveyed and not relayed to the criminal defendant, that alone is a constitutional violation and ineffective assistance of counsel. That would require hearing to go back and then examine all of these issues. So while I agree with Your Honor that maybe in the future that's going to be an issue as to all of these things pleaded, I'm not quite sure we are there yet, because all we are asking now here is that he had said what the constitutional violation is. Under Ardolino, there is nothing in the record that would refute it. Therefore, the court had an obligation to hold a hearing, so we wouldn't be standing here speculating about the answers to all these questions today. Thank you, Your Honors.
Thank you, counsel, for your arguments today. That will conclude our 1:30 docket. We do have a case on the 2:30 docket. And we will not take a recess. We will simply allow counsel to replace current counsel at the table. Great, thank you.
That's fine.
I'm local counsel, Your Honor. I was going to introduce Pro Hoc Vice counsel. My name is Patrick Cobb.
Okay, as long as he's already been admitted pro hoc vice, that's not necessary, but we appreciate that.
Thank you.
Well, and we're not yet ready to proceed, counsel.
Okay.
All right, I know there are people who are here now who weren't here for 1:30, so I'm going to reiterate a couple of things. Please turn off your cell phones if you have those. They tell us that they have to be off. Somehow they can interfere with the recording equipment that we have, and we do record the arguments and also live stream them. Also, of course, you know that each side will get 15 minutes, and the podium does go up and down. There's a toggle switch for that. Do you have any questions concerning our procedures? No?
No, Your Honor.
Okay. All right, then, we'll go ahead and proceed. Counsel?
Thank you, Your Honor. Dan Katz on behalf of Park Meadows. Because the original and new actions here rest on identical facts, the district court erred in holding that the remedial revival statute does not apply. The district court also erred when it sua sponte ruled on preclusion. I want to first address what constitutes the same cause of action under Colorado law. Black's Law Dictionary defines cause of action as a group of operative facts that give rise to one or more bases for suing. And Colorado law on claim preclusion strongly informs how this court should interpret cause of action.
Well, counsel, in the claim preclusion context, cause of action is interpreted rather broadly to bar claims, okay, as furthering judicial economy. We have the opposite consideration here, don't we? I mean, judicial economy would favor you should have brought your claims earlier.
I think, Your Honor, here there's a clear statute under these remedial revival statutes. They go back to 1623, and they're supposed to be liberally interpreted to give a litigant their day in court. So I think that they do serve different purposes. However, I think that the claim preclusion cases, since we have words used in the statutes that are the same, or in the cases in the statute, cause of action, how do we define cause of action, that they inform the inquiry? There have been cases, including Mabry versus Bowler, that we cite from Illinois, that say that claim preclusion principles apply to revival statutes where you're seeking a different remedy. So I do think that what we're doing here is interpreting the statute and trying to figure out what cause of action means. And I believe our interpretation that we've advanced is consistent with the liberal purpose to let a litigant have their day in court. And so we cite In re Green, for example, where a single claim embraces all remedies growing out of the relevant transaction. And that would mean that Park Meadows' claim for money damages is the same cause of action.
The Green case is interesting, though, because in the passage before the one you've quoted, the court actually used the phrase cause of action clearly to refer to a particular claim. So even internally, it's not all that consistent.
Yeah, well, I read it, they're following, though, the restatement second of judgments, and the comments there make it very, very clear that what we really look to are the operative facts, and are the operative facts the same? And of course, we have no dispute about that here. They're precisely the same, they're identical.
I'd actually like to ask a question about that. I'm troubled by the suggestion that the statutory violation and the breach of contract claims are I understand that they're both triggered by the same set of operative facts, that is GM's approval of Alpine's move. But for one, you've got a contract, and there may be defenses. You know, maybe GM would say, well, things were added to this contract later. Maybe there's parole evidence. Maybe they would say, we didn't actually agree to the terms, that maybe this is a photocopy that somebody altered. And so how can we say that they are the same operative facts when when the only thing that I think everyone agrees is identical is the triggering event?
Yeah, I think, because that's how I think it's defined. It's defined by, what the overall corpus of facts is that informs the right to relief. And I think that if you had an issue of amending the pleading, for example, which is another analogy we draw from the Roper case, you would say that as long as they're the same operative facts arising out of the wrongful approval of GM to relocate Alpine, that constitutes the same cause of action. I think that it's correct that, and this is true in the remedial revival statute, it explicitly says that the other party gets to assert all of their defenses. So we're not saying that GM should be precluded from asserting any defenses. The question is whether you basically have the same set of operative facts and it's the same cause of action. So I think that the statute contemplates that there may be different defenses, but I don't think that that impacts the analysis here.
Counsel, I want to take a big step back from this discussion of the remedial revival statute, and that's because I'm going back to the first decision, not the first decision, the decision by the other division in the other case. And they concluded their decision by saying that, like the district court, we construe Park Meadows' first claim for relief against Alpine and GM as a request for the district court to determine the reasonableness of GM's approval of Alpine's relocation. Because Park Meadows first sought the same determination through the executive director, the Court of Appeals had sole jurisdiction to review the executive director's decision. So, the court said that that claim asserted in the first action was barred as a matter of subject matter jurisdiction.
Right.
And in your reply brief, you say, and I quote, "There is simply no dispute that the same, quote, legal theory, end quote, a violation of section 12-6-120.3 of the Dealer Act underpins both Park Meadows' statutory claim in the original action," the one I just talked about, "and its statutory claim here," end quote. Why should we send this claim back if it's also barred by a lack of subject matter jurisdiction? It seems to me you've almost conceded that.
Yeah, I don't think so, Your Honor. This is not a collateral attack on that decision because the executive director is not a party in the new action.
Well, the prior division didn't view it that way either. They said it was a lack of subject matter jurisdiction. They said that claim, any claim that challenges that decision is barred by subject matter jurisdiction. And you say your claim now is the same as it was then.
I think that this claim is the same in the sense that it challenges the relocation, but it's not the same in that the executive director is not a party.
Well,
and we're no longer seeking to block the relocation. Instead, we're seeking damages because of GM's wrongful approval. And so I think that
but counsel, the prior division didn't say the executive director. It said, we construe Park Meadows' first claim for relief against Alpine and GM as a request for the district court to determine the reasonableness of GM's approval of Alpine's relocation. That's exactly what you're pleading now. And the court held that that claim was barred by subject matter jurisdiction.
I think that all I can say is that I think that it's a different claim here.
Well, you get damages, but that's just a remedy. You still want a second body to look at this question that's already been resolved, okay? And the prior division didn't resolve that issue on the basis of claim preclusion. It did it on the basis of subject matter jurisdiction.
Right, and I think that now, because the executive director is not a party, that it becomes an issue of claim preclusion. It becomes an issue of claim preclusion to see whether this issue, there was a full and fair opportunity to litigate it before the executive director. That's how I think that the case has changed, and the revival statute looks to whether a case was dismissed for subject matter jurisdiction. We clearly have that here.
But all it does is cure a statute of limitations violation. It doesn't cure a subject matter jurisdiction lack of that. It doesn't cure that. Would you concede that? You can't.
Well,
it doesn't create subject matter jurisdiction where none exists in the first place.
No, I think that's right. I think that the trial court, can. I think we're really talking about two different things, frankly, Your Honor. No, I think the remedial revival statute goes to the issue of statute of limitations.
Right.
And it's triggered by the subject matter jurisdiction. But I don't think when the executive director is no longer a party and we're no longer seeking an injunction, we're no longer challenging the executive director's decision, that then becomes, we're in the world of claim preclusion and not in the world of subject matter jurisdiction in a new case before the district court. The next thing, if you have any other questions, I can address that. The trial court imposed a diligence requirement that I don't think exists in the remedial revival statute, and said that Park Meadows could have asserted claims for breach of contract and monetary damages earlier, but didn't do so. The only requirement of the statute, as this court has held in Sharp Brothers, is that the 90-day requirement be met. The other party is on notice because the same operative facts are involved. Then on the issue of claim preclusion and issue preclusion, the executive director decision shouldn't bar us. The district court said that Park Meadows couldn't utilize the remedial revival statute because of some sort of preclusion. GM admits that it didn't ask the court to address the issue of preclusion. The trial court ruled on it sua sponte. This court has held in the Robbins case that that's inappropriate, that the other side should have an opportunity to be heard. The district court made no findings about preclusion.
Counsel, you suggest that GM is on notice of the breach of contract claim, but I went back and looked at the first complaint in this case, the one that was in the previous division's opinion, and I didn't see any mention of breach of contract in there.
Yeah, we do cite to some points in the record, including a prior mediation statement that we were reserving our right to seek contract damages. But I think that what's informative here is that under
Doesn't Rule 8 require, notice pleading?
right, I think that
How can a mediation
it's
statement?
well, it's a different. What it goes back to is, are you on notice of the operative facts that animate your claim? And the operative facts are the wrongful approval of the Alpine relocation. And in an amendment situation, the amendments are frequently allowed years into the litigation, even for a new claim, as long as they relate to the same operative facts, because the law holds that the other party is on notice, at least of those operative facts, what animates your lawsuit, and therefore you can amend and add a completely new claim, like a breach of contract claim. It's not a different cause of action.
Sure, but what animated the breach of contract claim was the existence of a contract, and that's not alleged in the original complaint.
No, you're right, that is alleged, but we would say is that what animated a contract breach is that the contract speaks to whether or not GM can relocate a dealership within its network in a way that harms an existing dealer like my client.
Which I understand is a statutory violation, as you allege it, but I don't see anything about the contract in there. That's where I'm struggling.
Right, and all I can tell you to answer that question is that the same cause of action requirement is met as long as the operative facts are the same. And you have remedial revival statutes claims where there's a different claim alleged in the first and second suit, that the other side can claim that they weren't particularly on notice of that claim.
Are you aware of any case law? Have you found any? Because I'll tell you I haven't. That whether in Colorado or elsewhere, where we've got a situation like this, where it's a statutory claim and then the claim in the second suit, the claim that you are attempting to revive, is a breach of contract claim or anything analogous to that?
I think that the Roper case, the Court of Appeals case here, there was an implied warranty claim that related back to the original claim for negligent home construction, because both of those arose out of the same transaction. I mean, that was a relation back case. So I think that that would apply here. We're looking at the underlying operative facts and not the specific legal claim. And the restatement has comments and example after example where that is permitted.
Counsel, I guess the question is, why isn't the contract an operative fact? The existence of the contract, that's a fact. Crucial, obviously, to the breach of contract claim, not at all required for any of the other claims.
I think that, Your Honor, what I would say is it's the transaction or occurrence. If you look at the law, whether it relates to relation back doctrine, whether it relates to preclusion, whether it relates to the remedial revival statute, and as I quoted from Black's Law Dictionary, group of operative facts giving rise to one or more bases for suing. And that would include a different action like a breach of contract action. In Foster versus Plock, which is a case from the Supreme Court in 2017, that case held claim preclusion was satisfied even though invasion of privacy was not inserted in the original case. It was a wholly new cause of action that was asserted. But under that broad and liberal view, which is how the remedial revival statute is supposed to be interpreted, even though it is a brand new claim, it would be covered. And there are many cases that speak to that, not specifically under the remedial revival statute necessarily in Colorado, but many other state remedial revival statutes that we cite in our brief.
But counsel, in that context, the court is essentially saying the claim is barred, not allowed, barred, because you should have known of it and you should have brought it. Okay, that's why there's this broad test. Okay, it's a matter of judicial economy. I'm just having trouble understanding why that sort of broad test would apply in this circumstance to achieve the opposite result, judicial inefficiency.
Because the remedial revival statute has a wholly different purpose, which is a very liberal application which is what this court has held and the Supreme Court has held, because what we want to do is ultimately have a hearing on the merits rather than having a claim dismissed for subject matter jurisdiction, which is what happened below. Because
But those claims, this is not those claims. This contract claim is different.
But
I
then,
mean, in
Your Honor,
other
at a
words-
minimum, if the court didn't think that the contract claim should go forward, then the case should be remanded to the district court for the statutory claim to go forward, because that obviously clearly was pled. Under that rationale, which, as I said, I don't agree with it, at a minimum, the case should be remanded so the statutory claim goes forward. And I'll reserve the rest of my time, if that's okay.
Yes, Counsel.
Thank you.
Good afternoon. My name is Mark Cloart, and with Jake Fisher, we're here on behalf of General Motors, LLC. One constant refrain that we've heard throughout the briefing and then just a few minutes ago that was about a liberal application of the revival statute. GM doesn't disagree with that it's meant to give a litigant a day in court. Again, no disagreement in the proper circumstances to that concept. However, in this particular case, there have been multiple opportunities for the appellant to be heard in court. There was the initial protest to the executive director. There was the second letter follow-up that was also denied by the executive director. There was the first district court action that was filed. And the interesting thing about that is that was a litigation decision or strategy employed by the appellant in spite of a clear statutory provision that said the correct place, if you're going to appeal that, would have been to this court, to the Court of Appeals. So for some particular reason, the litigant decided to go back or to go to the district court in that initial court case. And I was always taught in law school to always argue the facts, always argue the law first, and go to policy last. But in this case, the policy really controls in my mind. If you look at the case law, we cited to a case called Soner, and that was a divorce case that went bad. The wife eventually filed suit because she found that the ex-husband had hid certain assets. And so she went back after the expiration of the statute of limitations. And there was a discussion in that case about how it was appropriate under the revival statute to excuse the expiration of the statute of limitations in that case. She had not been heard. Her day in court had not been had because facts were obscured from her. So that's just not the case we have here. So in that first district court case, there was a litigation decision to assert, again, essentially a relitigation, a re-ask of the same question that was made to the executive director. In essence, did GM unreasonably approve the relocation? So at that time, they certainly, Park Meadows could have certainly included claims for breach of contract. They could have included claims under the statute for damages, for violation of that statute. Yet they chose not to. And instead of, when that initial dismissal came out by the district court, instead of kind of packing up and reviving their claims, if you will, within the statute of limitations, they pursued that litigation for about 2.5 years, all the way up to the Supreme Court, through the Court of Appeals to the Supreme Court, where the cert was granted and eventually essentially denied because it was improvidently granted.
Could they have pursued a breach of contract action in front of the executive director?
No. In fact, in their briefs, Park Meadows references a regulatory path, I think they call it, and a litigation path. And the regulatory path would be under the statute where the executive director could investigate, could issue a cease and desist order, and could actually impose fines. The litigation path gives a cause of action for violation of the statute, and that entitles the litigant to damages if proven.
So by starting in front of the administrator, they they gave up their right forever to assert a breach of contract claim? Is that your position?
I'm not going to go so far as to say that. I think they could have, because it's a different question. The damages question, it looks at the unreasonable decision and what the impact of that unreasonable decision is in damages. So that claim could have been decided in district court, and that's why I'm saying it was a curious decision not to appeal the executive director's decision to the Court of Appeals, but instead to litigate/appeal it in the district court level without asserting a damages claim along with it. And to me, there is a difference in the claim for violation of statute seeking damages and simply a violation of the statute seeking a cease and desist order. It's a different analysis because there's the damages component attached to it.
Mr. Clark, you talked about policy earlier, and I'm just curious. So I went, and this is the 2016 version. I had to go get this out of the recycling bin. But I think that we're under that 12.6.120.3. Would you agree that if you're asserting a claim for what I'll call injunctive relief, essentially the cease and desist order, that the 4 factors in 12.6.120.34A, that is the size and permanency of the investment, growth and decline in population, et cetera, that those seem to control the claim for injunctive relief or a cease and desist order. Is that right?
No, I saw that in Park Meadows briefing, and I would disagree with that concept. If you look at that provision, I believe you're looking at 12-6-120.34 A, I through, or 1 through 4. If you look at that A, it says it applies to whether or not a franchise was terminated, canceled, or not renewed. It does not apply to relocations.
You know, I originally read that in the same way, but if you go back and look at the Park Meadows 1 decision, they read that a different way.
I agree.
And so I think you're stuck with that. My question is really this: let's assume that those are the factors that either the executive director or the district court, depending on the venue, you decide to litigate in. Let's assume that those are the factors. So are those also the factors that would control a statutory damages claim? Or are there other things that would be relevant to GM's defense against a statutory damages claim?
Well, certainly, to the extent they can be considered, there are provisions within the dealer agreement, the contract between the dealer and the manufacturer, relative to the manufacturer's ability to place or make decisions relative to relocations, and I think that would be also applicable.
Okay.
And I would push back on any proceeding that would necessarily apply those 4 factors to a relocation, at least in Colorado.
Okay.
Yeah. I'd just like to sum up, because unless the court has any questions, there were several other issues that were raised in the brief. I think they're somewhat tangential to the real issues here relating to claim preclusion and the Exhibit A that was attached to the briefing by Park Meadows. But it's GM's position that it's not the purpose and policy behind the revival statute to allow a litigant essentially a third bite at the apple when prior litigation strategies went awry. That Park Meadows chose to file its first lawsuit with the district court, whether inartful or not, is not GM's or this court's issue. Instead, it was a litigation strategy employed by Park Meadows. The application of the revival statute simply doesn't fit the circumstances here. And I don't have any further comments.
Well, I'd have questions concerning the definition of cause of action in the revival statute,
Sure.
because, we have looked at cases from other jurisdictions, and they appear to take this kind of transactional approach rather than the kind of narrow claim approach. Do you have any authority that takes the narrow claim approach to a statute like this?
We do not, to be honest.
Thank you, counsel.
Thank you.
Mr. Katz, 14 13 seconds.
Couple of, I was just going to make a couple of quick points. First of all, I just want to make it clear that on your question about subject matter jurisdiction, that we're not asking in the new case to revisit any aspect of the correctness of the executive director's order. So we think that it's not a subject matter jurisdiction bar. In the Soner case, it says nothing about the interpretation of cause of action. And I just want to clarify that I believe the contract was referenced in the original action. In the Court of Appeals opinion below paragraph 4, it references a letter that was attached to the complaint before the executive director that references the contract. And if I believe I just heard my opposing counsel, he said that the contract terms are relevant to look at the statutory claim, which would mean that GM at least generally is on notice, but I would say that if you're
Counsel, your time is up.
Thank you.
We get the point, though.
Yep, thank you.
Thank you. Okay, that was the last case on the docket for this afternoon. We'll issue an opinion in due course, and we want to thank counsel for your arguments in this rather interesting and complicated case. We'll be in recess. The bailiff may so announce.
Thank you.